legal and the commercial frameworks for major strategic ICT initiatives. He has a keen interest in open source, and I've certainly seen him speak on this and many other topics similar before. Ladies and gentlemen, Tony Beal.
Oh, good afternoon, everyone. It's a pleasure to be here. Now, I can well imagine that when you registered for this event that you might have thought to yourself, the very last person that software developers would like to hear from is a lawyer. Well, thankfully, the organisers have arranged the speaking schedule to ensure that you get your wish. Welcome to Safety First, legal drill for software developers. I'm here this afternoon to be your legal life coach. And with the help of my patented knowledge transfer systems, I'm going to encourage you to drill some sound practices into your heads. It may not be pain-free for you, but hopefully it'll be entertaining, to me at least. Okay, where should we start? Well, anyone who pays even a passing attention to the news will be aware that lawyers seem to be circling the software development industry in an absolute feeding frenzy of litigation, particularly in relation to Android. So, is being an open source developer about as safe these days as being in a bomb disclosure squad? Well, clearly it's not that dangerous, but it is a lot less safe than it used to be. I'll be coming back to tell you a bit more about patents later on in the presentation. But the plain fact is that there is a very high casualty rate in IT businesses, but it's not usually external threats like litigation that wipes them out. What kills most IT businesses is that they blow themselves up simply by not taking heed of fairly basic risks and managing them properly. So what I want to do in this afternoon's session is to look at some practical steps that you can take as developers to position your projects for greater success and to improve your survivability if, despite your best effort, things don't go to plan. All right, let's start off with a fairly basic one. Licence compliance. Now, you probably think to yourself, licence compliance would be easy peasy for open source developers. I mean, after all, open source licenses are the unique characteristic that separates out open source from other types of software. There's only so many licenses out there and they're all pretty well understood. Well, hopefully that's the case. But then there's lots of things that are well understood to developers. Writing beautifully elegant, error-free code is something that probably is well understood for developers, but it doesn't always happen, does it? No, if wishes were horses, then code would be bug-free. However, is it a fact that no open source project is immune from the prospect of unintentional errors in their licence compliance creeping in? I know this is the case, because it's my job to check them every now and again. So, what type of problems happen? Well, sometimes they can be reasonably difficult problems, particularly strike Java projects, because Java projects typically have code from lots of different places, so lots of different licenses are involved. And it's not at all uncommon to come across genuine license compatibility issues. Can these problems be fixed? Well, invariably they can. I haven't come across any situation where they haven't been able to be fixed, but that's not the point. The point I want to make is these types of problems are completely avoidable by taking some fairly simple steps. Not paying attention to preventing problems has consequences. You know what the consequences are if you have unintentional errors in your code. And they're not all that dissimilar to licence problems. Cost. Cost is the enemy of projects. Cost blowouts, that is. Fixing problems is far more expensive than taking action to avoid them in the first place. Delay costs time to fix licence problems. We're talking probably weeks or months, not days, to fix them. Delay can kill what would otherwise be a great project. If you can't deliver it on time due to problems, the world sometimes moves on. One that might be closer to your heart is loss of faith. Now, if open source developers can't get their licensing right and this gets known to the world, it's going to blow a big hole in your reputation, both your personal reputation and the reputation of your project. And this is going to be more than embarrassing in many situations. I'll take a few examples where licence compliance audits take place that might illustrate this. One situation where licence compliance checks by external parties happens is within organisations. They might be government organisations or corporates, and management becomes aware that open source is starting to become a very important part of their technology operations. And there's always a gainsayer in there who says, oh, maybe it's a bit dodgy, you should get it checked out. So the lawyers come in to do some compliance checks. Another typical situation is entrepreneurial open source businesses. They want to expand, they need some investors. The investors look for some independent verification that the project's squeaky clean. So, losing the faith of your sponsor organisation that you can do things properly, scaring off potential investors can be very career limiting, particularly when things could have been done better in the first place. What should you do? Well, if you're still thinking this is just a problem that I'm making up, don't take my word for it. Take the word from the Linux Foundation, because they think it's a big enough problem to have gone to a lot of trouble to put together a very comprehensive suite of material in the form of the open compliance system to explain exactly on a step-by-step basis how to build good licence management practices into your development methodology. So take advantage of these resources. Those save you a truckload of grief. What type of things do you need to do? Well, I'm sure you're all aware of the benefits of code repositories. So we have a similar concept called licence repositories that are connected to your code repository. What's in a licence repository? Well, it's not just a tatty copy of the GPL. Just like you need to track different versions of your code, you need to ensure that each version of the code has proper due diligence to the licence information. So you need to put in your repository the license.txt files, the actual evidence of what the licence is and what you've done to comply with it. So the notices and things that you're putting in your distribution. Licence election is another typical thing that's a source of problems. Now, you'd be aware that many projects make their code available for use under more than one licence. Sometimes it can make a difference as to which one you go for. So if you go for one, no problems, fully compliant. If you go for another one, you might have a licence incompatibility. So, where there's licence election available, and where it makes a difference, make sure that in your distribution you've actually elected and for the one that works, and that you put that and you're clearly labelled in your distribution as to what one you're using. Checkpoints. Compliance is not an event, it's a process. So just like every time you introduce new code into your project, you presumably do regression tests. Well, similarly, you need to have checkpoints to make sure that when something changes, that you go through and check all your licence compliance material to make sure you've got the right records to demonstrate it. So this is all pretty easy stuff. It's really just a matter of following a methodology, just like good development process. All right, well, that's something you can do to lift your game that won't cost you very much, but can certainly save you a lot of grief. There's other problems that you can have where whatever you do, nothing's going to stop the problem occurring. Now, you're all doubtless familiar with the concept of sandboxing, so preventing one bit of code if it goes awry from bringing down the rest of the system. This is an idea that developers did not invent, they stole it from lawyers. If only we patented it. Except lawyers call it business structuring. Now, you'll be aware that most businesses adopt a company structure. There's reasons for this. There's quite a lot of reasons, but one's limited liability. How does this work? Well, here you are. Here's the gun developer who has got an idea that's going to change the world. It's going to start coding. Oh, hang on. The open source developers. Nah, that looks a bit better. Nevertheless, our gun developer has the modest developer's home, spouse, a vehicle. What happens if something goes wrong? Well, potentially everything gets burnt. So let's take two. Okay, now developers in place again. This time we're going to use a company structure. Now, it could be a proprietary limited company if you're an entrepreneurial type open source outfit. It could be an incorporated association if you're a community effort. The principle's the same. Things go wrong, company asset gets burnt, you still get to drive your neat Mercedes home and sit around the pool drinking martinis and cry your eyes out and hopefully start again. Okay, what are the tips and traps with business structures? Cost's always one, nothing comes for free. Protection's always going to cost something. Although these things come at a cost, and it might cost a couple of $1,000 to some company, maybe a couple of $1,000 a year to run it, you need to think of it as insurance, don't think of it as a cost to the business. What it's there for is to protect your assets, which could be many hundreds of thousands of dollars, protect you from nasty things like potential bankruptcy, which could haunt you for a long time, make it difficult to raise money. Certainly in terms of cost, the benefit of a company is a lot better value than probably your professional liability insurance. You do have liability insurance, don't you? Another trap is not acting like a company. If you set up a company and gone to the trouble to do it, you need to actually act like a company. So it's very easy for small businesses, family companies to muddy the waters as to what's a company activity and what's your personal affairs. Things like using the company checkbook as your own checkbook. I'm a bit short of money this week, let's write up a check from the company to come pay for the groceries. Companies have to make the decisions, so you have to have meetings and keep minutes of meetings of a company. You have to actually take account of your obligations as a company director. If you don't do these things, then you've opened up the way for nasty lawyers to find a way through to attack your personal assets. Also keep in mind that secured creditors, like evil things like banks, although they might be lending you the money, will take security over your mortgage over your house, for example. That doesn't mean that the company structure is not a good idea. It is. It just means you have to think of ways to get your assets out from the realm of the bank. We can have a look at some of those in a minute. Okay, so that's a very basic structure. What can you do to improve on it? All right, well, as well as liability structuring, which is the benefit of survivability, you can talk to your accountant. There's lots of things you can do to tax structure to improve your profitability. Some of the things your accountant suggests might even be legal. Your business advisor will probably come up with all kinds of wonderful ways that you can use structuring to make your business more attractive to investors, or sponsors, or to all kinds of people. So you need to keep a lot of things in mind. Okay, let's have a look at an example of what a more sophisticated structure might be. Our developer again, we've got our company, accountant says, okay, well, how about we add some trusts to this arrangement so we can finagle the income, split it. So we've got a discretionary trust in this one. So some of the money goes to you, some of the money goes to your spouse or other needy relatives. Talk to your lawyer. Talk to me. I'll probably ask you about your operations. Do you have some that are more risky than other bits? Do you have some decent assets in there? Do you have some nice income streams? Split them up. So how about we put our development arm to one company, because that could be rather risky. You don't get paid unless you deliver. From your maintenance arm, which produces a nice income stream, relatively low risk, because you don't actually promise to deliver too much under software maintenance contracts. You might put your IP, your code, that's your core asset as a developer, a separate company again to keep it further away from risk. So what are the tips and traps in structuring? You need to think strategically about what you want to achieve. You need to tell that to your advisors. So if your aim is to go public and make a big splash within 5 years, you're going to adopt a completely structure that if your open source development effort is, part-time business, not your main income stream. Get advice from all perspectives. Don't just talk to your accountant. They'll have one part of the picture. Talk to your lawyer. Talk to other people who are already in business and see what they do. Get the full picture before you leap into anything. Always right size now your advisors, be they lawyers, accountants or anyone else. They always like to make things more complicated than they possibly need to be. Make sure you do a reality check and make sure that you know what it's going to cost you and how it's going to work for you. Plan ahead. Some structures are more difficult to shift than others, particularly ones like things like trusts in them, because they're difficult to unwind when you want to get to the next stage of your business. Well, we talked about putting your IP in a separate entity before. Why would you want to do that if you're an open source developer? You've made your code available to the world, anyone can pick it up. There's a difference between your rights as the copyright holder, where you've got a big bundle of rights, to your rights as the licensee. So there's a number of reasons why you might want to put your source code base into a separate company. Maybe that you've got a dual licensing model for your open source development. So if things go wrong with your development arm and that goes broke, you may want to make sure that you can fall back as the copyright owner and be able to resurrect your business to keep your commercial clients happy. Maybe that you can take the dual licensing model and you want to prevent that type of thing happening, which is exactly what could happen if you've got your copyright in your operating company, because if you go broke, the liquidator's going to sell up your assets. So your code, the rights in your code could be sold to a party who's hostile to the open source movement. And then they could use that to create a parallel commercial version that could stop your open source project from flourishing. Distance, talked about that before. The more firewalls you've got between the sources of problems and you, the better. Now, these last two ones, sort of hostile takeover of code and distance from developer, they're often arguments that are put up in relation to contribution agreements. So I know that contribution agreements are one of those sort of holy wars in the open source community, and it's hard to generalise. There's lots of different types of contributor agreements. There's ones that just get you to swear black and blue that you actually own your code and you're not aware of any patent infringements in it. There's other ones that require you as the developer to assign your code, either copyright on your code, or either absolutely to the project organisation, or to appoint them as a dual copyright owner. Is this a good idea? Does this idea work for developers? It obviously works from the organisation's point of view. Well, one of the arguments that gets put up is that assigning your copyright to the project is necessary for proper licence enforcement. Now, I've looked at many instances where open source licences have been enforced, and I've yet to find one where consolidated ownership in the project organisation would make any difference. So I don't think that was a convincing argument at all. What about the one that it shields the developers from becoming targets for lawsuits? Somebody's going to get sued, it's going to be the sponsoring organisation rather than you as the developer. Well, that's a bit like security through obscurity. Because you've got a sponsoring organisation that's perhaps taking the front line, sure, it's more likely they'll get sued, but there's nothing from a legal perspective that stops patent troll or somebody else, or somebody who's looking to frustrate the project from hitting a few of the key developers. In fact, it'd probably be a good idea to do that if you want to disrupt an open source development team. So there's no real protection that's given by consolidated ownership under a contributor agreement. So And if you wanted to achieve that kind of protection, you're better to do it yourself by the type of structuring I was talking about before. About this one. Consolidated ownership provides flexibility to easily change the project's licence. Well, that's true. If you've got sponsoring entity, the copyright holder in all the code, it makes it very easy for the project to change licences. Think of it as if from a developer's perspective, is that really what you want? If you've gone into a project on the basis that it's adopted a certain type of licence, would you really be happy if you supporter of permissive licences if it was suddenly changed to a restrictive licence? Maybe, maybe not. Some organisations, it could even be changed to a commercial licence. Those that are backed by foundations and things usually have rules that prevent that. So, whether that's a good idea or not really depends on a number of things. I mean, what you're contributing is a key factor, and who you're contributing to. There are other ways to get flexibility in changing licences for projects, particularly if you adopt a licence that's sort of version X or later, that gives the project an ability to move to a more modern licence if the wider community deems that necessary. Right, let's get to the software patents, which is probably something that you're more acutely interested in. Is there a software patent bullet with your name on it out there? Well, quite possibly. Now, you may be aware, before we get to the patent issue, maybe we'll talk a bit about IP in general for computer programs, but you're probably aware that original published works in the form of computer programs are protected automatically under Australian law by copyright. Copyright is literary works. That might surprise you a bit, your outputs are literary works. So I guess that proves a couple of things if computer programs are literary works. First of all, it definitely proves that lawyers do have a sense of humour. It also dispels the scurrilous rumours out there that programmers are illiterate. You're clearly not. You're producing literary works all the time. You may also be aware of the concept in copyright that, the legal maxim that says that you can't copyright an idea. You can only copyright the form of an idea. This is true. This has some good implications for programmers, because what it means is that if you've written your own code, you haven't copied it from anyone, then you can be basically completely assured that you shouldn't have any IP difficulties. Somebody trying to sue you for infringement. If they do, you should have a solid defence. Okay, so that's good. Enter software patents. Now, software patents have been around for quite a while, back to the 1960s in some cases. They really only started to take off in the 1980s. Particularly, they only started to become a major problem for software developers in the mid to late 90s, the dot-com era, when wondrous things like the electronic shopping cart patent and the one-click purchase patent from Amazon came to the fore. So, what's different about patents? Well, probably not worth going into the ins and outs, the details of how patents work, but probably what you need to know is that if you're the holder of a valid patent, what it allows you to do, what rights it gives you, is allows you the exclusive right to exploit the patented invention that you hold. So that means only you can use it, or somebody licensed by you. Anyone else is using it, whether they know of your patent or not, is an infringer. And if they're an infringer, nasty things can happen to them. They can be sued for damages, they can have injunctions taken out over them. They can have their infringing material seized. This is obviously bad if you're the defendant. So, what are the difficulties for patents in particular? What's the heart of the problem? Okay, well, the heart of the problem is that original code's no defence. So, the fact that you've coded away in good faith without knowing that there's a patent out there that may collide with what you're doing is no defence. So it puts the onus on the developer to find the patents. So effectively the situation is that you have to find the patent before the patent owner finds you. This is somewhat challenging. How do you do it? Well, you have to search the patent register. Now, there's a patent register in every country, so there could be lots of patent registers to search. Time-consuming logistically, quite difficult technologically. You also need to know what it is you're searching for. Now, when you're writing your code, it can be quite difficult to work out what conceivable inventions might be crossing my path in this. You've got a very good idea when you start your development project about what you're doing, and you've worked out what you think might be unique or new or wonderful. Your program, it can still be quite difficult to search the patent registers in any kind of logical fashion. Even if you do, you've done a good job, you've gone out there and done your searches, okay, so you think you're in the clear, you start coding. It might take some time to develop your master work. Let's say it only takes 6 months. What happens in that period? Well, just in the US alone, there's 100 software patents registered every day. Another 200 IP patents of some kind could conflict with what you're doing. So business method patents, for instance, so that's 300 a day. So let's say your development time is a modest 6 months. So that's 300 patents a day, that's 9,000 a month, so that's what, 54,000 patents have arisen just while you're developing. It's a continuous process. What happens if, despite your best efforts, somebody comes around and hits you with a writ? It's not like copyright. If, despite your best efforts, some infringing code has got into your project, you can just take it out, write it from scratch. Mightn't solve the problem going backwards, but it would certainly solve the problem going forward, so your business can continue disrupted. Patents don't work like that. You don't have too many choices. If it's infringing, it's not going to be infringing going forwards and backwards unless you can do 3 things. Unless you can license it. And that's typically not something that's a option for open source projects. You can lawyer it. Now, this is a wondrous thing to do. Excellent value to put lawyers on the table. What do lawyers do for you? Well, they can try to invalidate the patent. Now, the legal mumbo-jumbo there, they can string that out for years. This is a good thing. Now, if you're lucky, they might be able to come up with some nefarious way to try to work around the patent. So let's say you've got your interface there and you found out that you've implemented something that infringes Apple's wondrous invention of the swipe to unlock command. Well, maybe your lawyer can suggest something else. You know, maybe rather than swipe to unlock, you can use 2 fingers and twist it like you're doing a doorknob. Maybe that will work. Still going to have to recode it though. If you can't do those things, then you have to leave it out, which will blow a substantial hole in your development effort. So just to give you an idea of what kind of threat patents do pose in practical terms, I mean, let's take Oracle and Google. Now, when Google developed Android and decided that it was going to run its own virtual process machines, they called Delphi. Now, they were rare, but they needed to be careful about IP infringement. So they developed it under clean room conditions. You know how much dust there is in an Intel fab? Well, it's the same type of thing. There's no contamination in the programming team. Pick people who could be absolutely proven to have no contamination of Sun's original Java code. Now belonging to Oracle, of course. Google's an organisation of not inconsiderable means. They doubtless had an army of lawyers searching the patent register and doing everything they could to make sure it was squeaky clean. But what's happened? Now they're facing a $2.6 billion lawsuit by Oracle, and that's just the start. The damage is likely to climb way beyond that over time. It's been going for well over a year now. It hasn't got even within cooey of getting to court, so it could be easily another 5 years before this goes on. A big question mark over it. So, if an organisation like Google can't work around this type of problem, what chance do you have? Well, is that really the point? There's lots of problems that you can't necessarily do something about. Every time you get in your car, go onto the road, there's at least a chance that a truck's waiting out there for you and is going to crash into you through no fault of your own. These are risks. It's how you respond to them that really matters. My thing is, don't be complacent. So you need to have a plan. A plan on the road might be, well, drive a safe car with airbags. Keep your seatbelt on. Drive safely. Might be able to knock out 99.999% of deaths on the road just by keeping safe. That's a plan. Don't be complacent on the software development. You need to think about exactly what you're doing and what's a reasonable response to the threat posed by patents. And obviously we've got a very small project. It's not going to be economic to have some kind of vast response to the IP threat. That doesn't mean you shouldn't do anything. There's lots of things that you can do. Let's think about what some of those things might be. What would happen if a lawyer suddenly rushed in here with a writ for you? What would you need to do? One thing you'd probably need to do is you'd need to go out and get your own lawyer. So, do you have enough cash set aside for a fighting fund? If you don't, maybe you should build some contingency into your operations to make sure that you do have that resource available. What type of steps could you take in designing your project to make it as easy as possible to take something out that might be a patent infringement? A lot of patents relate to user interfaces, so if you separate out your user interface from the rest of your project, that might make it easier to take some action. Have you taken the action we were talking about before? Have you thought about the structure of your operation to make sure that it does get hit by a patent suit? That you can let the fires burn if needs be, and still move your project and most of your assets and your operations onto something that's can start again fairly quickly. These are all pretty easy things to do that won't cost much money, give you a high degree of protection from realistic patent threats. What else can you do? Well, it's a really good idea not just to ignore the patent problem and think it's going to go away. It's not. Do some searches. It's not necessarily expensive. In fact, you can do your own searches in Australia because the patent register is available for searching. It's not probably easy for non-lawyers, for most lawyers, to do thorough searches. But look, for as little as $2,000, you could get a patent attorney to have a quick look to see if there's something obvious that might be cutting across what you intend to do with the project. So spending a little bit of money could save you a truckload of grief in terms of avoiding a bear trap that was so obvious that you'll kick yourself if you didn't look for it. Review regularly. Again, risk management is not an event, it's a process. If you've done some searches and taken some reasonable steps when you start out, it might be a small-scale project. Make sure you have processes in place to look at things again. Now, it's a lot different if you've got $50,000 worth of work effort in your project than if you've got $1 million worth of effort in your project. Things need to be scaled up. The more you invest, the more it's worthwhile taking action to make sure that you're not going to be hit by problems. All right, well, that sort of brings us back to where we started. There's plenty of bullets out there from the legal realm for developers. Some of them you won't be able to dodge, but many of them you can. Most businesses fail because they've blown themselves up, so hopefully in this short period of time I've drilled something into your head, and that's that you need to take reasonable action. Don't blow yourself up. Live to fight another day. All right, I'm quite happy to take questions. I'm rather deaf, so I mightn't be able to hear you very well, but maybe somebody could relay the question to me if you've got any issues. Yes?
You talked before about not needing a organisation to move a licence potentially. We've talked about this in one of our projects where developers are gone, we can't even contact them anymore. Yep. How do we move the licence forward without their permission? Removing their code is really not an option.
Yeah, well, I mean, there's always horses for courses, and look, I would agree that the arguments go, every which way.
We don't want to move our code to an association. We like being individuals,
yep.
But we do still want to try and work on a way to move up a licence version number.
Well, okay, there's two principal approaches that you can take to that. I mean, the first one is to go the licence versioning number, which means that whoever, the community needs to decide when you go to version 3 from version 2. Right? So that can take some time. You could also adopt an approach whereby the decision of what licence applies is entrusted to a trusted third party, a sponsor of some kind that is hopefully free from the politics of sponsoring organisations. But there's really no easy way to do that. I mean, the third way is to make sure that your project does carefully track who's contributed code to it and have a reasonable prospect for being able to track them down and get their permission. If you can't get everyone's permission, then you can't move the licence unless you decide to take out the code of the people that you can't reach or won't agree to it. Does that help? I mean, it's just one of those problems that.
Yeah,
it's not so much that there's an easy solution; it's whether the solution is worse than the problem in the first place. That's the yes.
I take issue with your suggestion that open source developers should read patents for a number of reasons. First of all, because in many cases the budget is zero. Secondly, because in many cases the developers are individuals and are from all over the world. And thirdly, because many patents don't actually teach in a useful form that you can learn anything from, or because they're highly likely to be independently reinvented. So they provide virtually no value to developers, and there's just no benefit that developers can gain by reading. But certainly for organisations with funds,
yep.
There may well be value in your advice, but for projects that are not run by organisations, they're run by individuals with zero budget, I just can't see any merit for that advice.
Well, I mean, obviously you've got no assets and you don't worry too much about being sued. That's right. Yep. Particularly if there's thousands of small guys in there that... but don't think it's all about money, because the threat's moved on to some extent. We've seen the threat of patent trolls. Patent trolls, according to some research that was available in the last couple of weeks, are scoring $80 billion a year out of people. But it's not just patent trolls anymore. These are tactical plays to wipe out competition. So the mere fact that you're small guys, they're not after trying to get your assets, they're out to explode your project and make sure that it's not competing with theirs. Yes?
Well, I am an open source developer. I'm also a mathematician, so I do read patents, and I've been taking a look through US patents, especially United States patents,
yep.
For quite some time. And the main thing I noticed is that there are some very, very broad patents on mathematical algorithms out there, which are still on the books. Some things, I've just pulled up the fast Fourier transform, patents on modular arithmetic, patents on the if statement, patent on lambda calculus. So, in other words, every possible calculation that anybody could ever do.
Yes. That's very interesting.
Defend against the patent on the lambda calculus, which is like everything.
Well, I mean, it's you've got to have an invention to patent it, and that should make patenting mathematical concepts impossible.
Yeah, no, there's a lot. There's a universe.
Does it happen?
Doesn't happen.
The US Patent Office doesn't have to try very hard because their incentive is to grant as many patents as possible, and the rejections can happen later in the course. There's absolutely no penalty for a US patent examiner to accidentally pass something that shouldn't have been passed.
Yes, most patents will work from that point of view, because they're patenting things that are overly broad or overly abstract.
And occasionally in things that have already been patented before and have expired. There was a celebrated case where Microsoft got a patent on something that Apple had already had earlier, and then after it expired, Microsoft just captured it in different words and got it again.
So if you do read patents, you read a lot of stuff that's bullshit. The majority of software patents are just rubbish, but they're useful to corporations and lawyers, but not developers.
Well, you sort of hit the heart of the problem there. I mean, look, I'd agree with that. There are a lot of patents that are rubbish, and they shouldn't be on the register in the first place. Once they're there, it means that other people have to go to a lot of trouble to invalidate. On the other hand, you know, Americans in particular make a big hoo-ha about how wonderful they are at protecting IP and, you know, God save the president type stuff. So,
All right, we'll take 3 more questions. 1, 2, 3.
right, who's next?
I'm enthusiastic to contribute to open source as a consequence because it's complicated and it's confidential. Listening to your talk, I feel like it's a great big rain cloud, and you start killing my joy that's happened over the last couple of days. Can you tell me why I should be motivated?
What was the question?
Why should you be motivated to develop open source? Why should you be motivated to develop open source? With all of this.
Well, I guess that's not really for me to say. You're the open source developers. You should be motivated to do it because then you can invite me along to your conferences. Lots of legal advices to open source projects. These are wonderful things. It keeps lawyers off the street. Otherwise, society may be in chaos. I don't know. I think it's a wonderful concept, and you know, it's a good thing. So it's a matter if you decide just to what you get out of it and what motivates you to do it. Right, do we have any other questions?
I was under the impression, although this may not be an Australian thing, maybe that's why you didn't mention it, but I was under the impression that you get in more trouble if you were aware that you were violating a patent than if you were to accidentally violate a patent.
Oh, well, look, that's not strictly speaking true. Obviously, if you're willfully going out to violate a patent.
No, I'm more meant, like, let's say you do one of your reviews that you're recommending, and you read 20 patents, which is a very small number, and you don't think any of them apply. You continue on with your product, you sell your product, and then someone comes back, one of those 20 patents, and says, you're violating this, and you're like, how on earth am I violating it? And they say, but we know you checked out the patent, so therefore you're willfully violating it when you're like, I didn't even think it applied.
Well, I mean, if they do actually know that you did check and you ignored it, I guess that's something that's probably unlikely to happen. But, no, look, I couldn't agree that not doing anything is better than doing something, because you won't be able to avoid problems. Ignorance really isn't an excuse. So, it's typically the case that even if you haven't found the patent that hits you, if you can demonstrate to the judge that you've taken some responsible steps, you've done everything that you reasonably could, that will work in your favour, that the judge is allowed to or not. So I'd really recommend that you do that rather than turn a blind eye. Now, as I say, it's really a matter of what's reasonable in the circumstances. You can't expect a small effort to spend hundreds of thousands of dollars on patents and doing things. It's just if you can demonstrate that you've done something. So that's another aspect to it, I guess, is to keep records of what you've done so that you can establish what steps you take.
So, oh, sorry.
Adam first.
given that doing something is better than doing nothing, what can we do to help fight really, really stupid patents?
That would be a crusade of another kind, I guess. Look, certainly efforts that are out there to, as I say, look at the patent registers and see which ones are rubbish and try to put that information out. Assistance. In terms of invalidating patents, obviously people who have got information about prior art say that the patents weren't original. That's a good thing if you have a look at the...
But where do you send the evidence of prior art?
I mean, if you have a look at the SCO case, I mean, it's just amazing the types of things that people in the open source community came at. People dug up original typewritten documentation for Unix and proved that things have been around for years. It's just amazing amount of stuff out there. So there are things that you can definitely do to help the process. But I mean, it's 100 patents a day in the US alone. It's, you know, it's sort of a bit like kindergarten. Turning back the tide is going to be fair and hard. And the main thing is to lobby government to try to get a bit more sense of the system.
One last question, and then if you have any other questions, come down and talk afterwards.
Wouldn't it be better to get rid of the software patents entirely? They don't seem to me that, I can control the patent system and find something that goes against the code that I'm writing. But so I now have to stop writing the code. I mean, they do stifle innovation. How can we fight to stop software patents, to get rid of software patents?
Well,
I mean, I had a letter I once wrote used as prior art against a patent case. But that's very much after the fact of somebody suing somebody with an awful lot of money going into that hole in the ground like in the SCO case.
yep. Well, look, you can certainly lobby the government because they do respond to pressure groups, but you need to keep in mind that this is not just an Australian phenomenon, it's an international phenomenon, particularly for the US, so putting pressure on the Australian government's good, but the US government puts pressure on the Australian government. So it's not easy to turn this around. So every voice counts. I think that has to be right. It's true that the Australian system is a lot more vigorous than the US one already.
I'm not Australian.
Yes, yes, yes. So, I mean, proper examination to weed out the rubbish before it gets in would be an enormous step forward. But when you get to these very broad, nebulous type patents, I mean, they should never be there in the first place. They're just, as you say, complete rubbish. But it's the Americans that have to be convinced if there's going to be any cogent action on this.
I'd like to warm round of applause for our... If you have any further questions for Mr. Beal, come down to the front and have a little chat.
I'll hang around.
Otherwise, we're all going to the pub, and you're welcome to join.